Well, good afternoon, and thank you again for joining us for lunch. I'm Donald Kochan. I'm the Deputy Executive Director of the Law and Economics Center at George Mason University's Antonin Scalia Law School. And we are honored today to present to you, as part of the luncheon discussion, a presentation and then some questions and answers with Victor Schwartz. Victor graciously agreed to spend some time with us to talk about the past, present, and future of civil justice. And I'll turn it over to Victor to give some opening remarks in just a moment. But I wanted to introduce Victor. You all have, well, actually, before I introduce Victor, just a quick note on format. As with yesterday's luncheon, there are 2 mics available at each side of the room. Please feel free to go up to those mics at any point in time which you have a question. We'll go for a little while up here talking to each other, but we will certainly open it up and line up at the mics if you could, and we will engage for the remainder of the time. So back to our program then, and away from the logistics. So we are honored to have Victor Schwartz here, and you do have Victor's full bio in the, or truncated bio, I should say, in the program. But I thought I would give a bit of a categorical bio to Victor as we introduce him and before we turn it over to him to talk. So Victor wears a lot of hats and has worn a lot of hats across his career. So he was dean of a law school. He was the dean of the University of Cincinnati College of Law. He is a professor of torts and other matters, and so he's worn that hat across time. He is a scholar, having published well over 100 law review articles, well over in leading law journals, as well as tons of other work. He has also been cited more than 2,000 times just using his middle initial to get to the most specific ones in the JLR database in Westlaw. He is a textbook and treatise author. So among those works, many of you are familiar with Prosser, Wade, and Schwartz on torts. He is also obviously a practitioner in which he does both work as a litigator, but also as chair of the public policy group at Shook, Hardy, and Bacon, and therefore a government affairs expert. He is a leader in the academic community and a distinguished member of the legal community. We were just talking about the fact that Victor has been a member of the American Law Institute, for example, for almost 50 years. And if anyone, I know that many of you are members of the ALI as well, and Victor certainly keeps the ALI on its toes. If anyone's been to an annual meeting of the ALI, you know that Victor pays very careful attention studying all of the restatements and drafts that are put out, and you can always count on Victor giving extremely informative, cogent, and important insights to the drafters and reporters of those restatements at those programs. And we all benefit from the amount of time and careful attention he gives to providing suggestions and critiques on each of that. Victor is, of course, a public intellectual, publishing op-eds and other matters, and I'll probably ask him about a couple of those as we go along. And there's obviously many more hats that Victor wears, but I'll tell you just at the end about 2 more. And one is that Victor is a friend of the Law and Economics Center, and certainly one of our closest advisors, and someone who has been at the Law and Economics Center for as one of its advisors for many years. And we count on your counsel and trust your advice, and we really appreciate all of the service that you've given to the Law and Economics Center in helping us both craft and launch judicial education programs for well over a decade now, and so thank you for that. And then lastly, I'll just say that he is a friend and mentor of mine. So I feel like this is a great privilege to get an opportunity to sit up here and talk to Victor for a bit. Victor and I first met when I was a summer associate back in 1997 at Kroll and Mooring, and then I came back in 1999 as an associate at Kroll and Mooring, and got an opportunity to work with Victor and his team at Kroll, doing a number of different projects, both in litigation as well as in public policy. I learned a great deal in all of that time, both about the law, but also about life and managing a career. And so I owe a lot to Victor I also believe that that time helped position me for many of the things that I would go on to do. Certainly, my move to academia was inspired by the intellectual rigor of the work that I was able to do in private practice. I loved seeing the way in which ideas and practice could come together to improve the law, and I think that that's always been a hallmark of what Victor has done. And if you'll indulge me, just one final story. That is, when I announced that I wanted to leave the firm and go off to pursue an academic career, Victor was the first one to invite me to lunch and tell me, let me take you out and tell you a little bit about the academic world and to congratulate you. And so we had a fantastic lunch in my last weeks there at the firm before I went off to join George Mason, where I was in 2002, joined as a visiting assistant professor before going away for 16 years and eventually coming back a year and a half ago to Scalia Law. So I've appreciated all of the advice that you've been able to give me over the years, Victor, and I know that you will have great insights for this crowd. So I'm going to turn it over to you to tell us a little bit about the past, present, and future of civil justice. And
okay.
There you go.
President Clinton, you want to say something? Yes, I do. I'll bet you that Schwartz made you pay for that lunch. I'm sure he did. He's cheap. Yes, Mr. President. Anyway, I'm glad to be here. I mentioned to you all, and Don has done, mentees have just been terrific. I also want to mention two of my colleagues who are here, Chris Appel and Phil Goldberg, who, if I'm bad, it's my fault. If I do well, they help me a lot. And my friend Mary Shibo, who's a very famous aviation lawyer. It's the first time I ever brought a guest to one of these, but I know that she would appreciate you judges. A judge asked me, and this was a few weeks ago, how did you get into this business of talking to judges? Well, when I was 32 years old, some of you have heard this, a judge named Harry Spencer was on the Supreme Court of Nebraska, and he called and he said, do you want to do judicial education? I was scared to death. It's frightening to see all these judges. But he said, just be yourself. And I looked him up. This guy, Harry Spencer, you can look him up. He lived to 104. And all I thought of is the Bible and original sin. That poor man had put me in front of judges, and it lasted all that time. And he must have thought about that. Tort law is changing all the time. I wouldn't sell case books. I wouldn't have new editions if it didn't change. Oh, by the way, during the pandemic, I learned something about my case book. I've been on that thing 40 years that I never knew before. Now think, what could that little guy learn about his book that he never knew before? Well, I'm at home, and I know how to cook. And I learned this case book. Has anybody ever seen it? Prosecutor Wade and Schwartz? It's like this. If I stood on the case book, I didn't need a ladder to reach the top shelf of my kitchen. One time, the White House, I was working in the government, wanted to send over some White House fellow. And I asked the men and women, did you take torts? Yes, I did. Do you remember the torts teacher? No, he was no good. You remember the case book? No. Some kid finally comes in. I could see, had a suit on. He said, I remember torts, and I remember the case book. It had a yellow insert and a blue cover. Man, next to sex, I was so excited. Here was somebody who knew. And he said, I knew the authors. I said, who are they? He said, Prosser Wade and some other guy. So with that, tort law changes when scientific things are discovered. I think about before, I think it was 1946 or so, if a child was injured in the womb, he or she could not bring a claim because the science could not tell whether that injury occurred from something external. And tort law changed, and they recognized claims. And you as judges, those who are appellate judges can change the law. Trial judges, I have found, do make changes in the law. They're modest. Sometimes they want to see what's going to go on with the appellate court go along with change. And I'm really going to talk more about the future of what I see. It's just a few key things in tort law, because the past you all know about, the present, that's this afternoon. So I think more talking about the future is good. And there are a few areas of tort law that are being pressed to the edge. One is called loss of chance. How many of you have heard of loss of chance? A few. This is different. With medical malpractice, if a doctor commits medical malpractice and causes a death, the doctor should pay. With loss of chance, a doctor gives a diagnosis. He says, you don't have cancer, you have pneumonia or something. It makes a bad mistake. The patient goes to another doctor and lives. But the first doctor reduced his chance of recovering from 70% up to, or went down from 90% chance of recovering to 70 or 75. Well, he made it. Now, should he get money? If he doesn't make it, should the heirs get money for loss of chance? I'll bet you almost every judge in this room in the next 5 years is going to see one of these things. And what do you do with it? How do you determine damages? Well, the august American Law Institute, which has all got all these people who use big words. I learned more big words to call somebody an SOB there than any other place. Oh, the gentleman, he means a real big SOB when they say that. I learned that at ALI. That's the stuff I learned, not law, stuff. Well, they are doing a restatement called concluding provisions. I thought they meant that was it. They were shutting the ALI, or maybe it was a funeral thing. But it's about tort law, and it's about parts of tort law that often were not covered in the second restatement, yet are part of tort law. And concluding provisions, loss of chance is in there. And you can get it online and see what they have to say. Right now, they like it. So over here is concluding provisions. Over here is the other one. This is going on right now with all the pointy-headed, I can't see, is this taped? The pointy-headed intellectuals up at the ALI like me, I'm not so bad. So the other one is remedies, and that covers virtually everything in the law of damages. During the pandemic, the restatement of torts was cited over 2,000 times. There is nothing in America that's cited more frequently than the restatement of torts, and this is restatement of torts third. So they got to coordinate concluding provisions and remedies. So remedies tells you what the damages are. And they have about 3 different options. And I stay awake, you can tell that. But when I was reading all their options, I did doze off, I admit it. Oh my God. So judges, if you get into this, make sure you can figure out what are the damages if the person's loss of chance results in their death, or if the person's loss of chance, they're still alive. Another one that's right on the edge, also addressed in concluding provisions, is medical monitoring. Now, I learned in tort law at Columbia, and I had 2 good tort teachers, especially Willis L.M. Reese. I could imitate him perfect. That you had to be injured. That was like duty, injury, or they called it damages and causation. See, I still remember, those are the 3 things you need to know. Well, the person comes into court and she's not hurt. There's nothing wrong with them. But something might happen to them. So down in West Virginia, there was this big case, Westinghouse versus Bauer, or Bauer versus Westinghouse. Well, they liked it. Down in West Virginia for a while, the courts changed. They like anything that came along that would expand liability. That's fine, you need that. But they bought it. But no safety guards. There was no showing that the money would be used one day for medical monitoring. There was no showing with any degree of certainty that the person would get sick. There was no place to put the money so that the person could use it, all that stuff. Spike Maynard, who was one of my favorite judges, he was a great character. He dissented, and then he wrote an op-ed and said, the court had rendered a decision helping every West Virginia buy a pickup truck. I mean, that's good judge speak. That was good. I like Spike. Well, the other states usually rejected it. This new draft restatement accepts it. And it tries to put in some safety rails dealing with some assurance that the money can be used for the actual harm that might go about. But they can't figure out how to do it. Can you, as a judge, set up a trust? I don't think most of you can. They do have a high requirement that you're highly likely to be sick. They attempted and then didn't. I think you shouldn't have the collateral source rule. I mean, if the person's getting money for some other place, why give them medical monitoring? Because typical, if you think about a drug company, maybe they have a bad drug, they've injured 400 people, but 1 million people use the drug. So if they all get medical monitoring, what happens to the dough to pay the injured people? So you've got to hold this tort tight. That's all I would suggest to you. But you're going to hear about medical monitoring. It's being pushed in a lot of states. Most states have rejected it, but a number of states have put it into place. But think about the guardrails if you put it in. And the restatement draft has put in guardrails, and that's part of it. The third edge of tort law right now, I didn't even know about, and I've been in this business a while. I didn't know about it. But I'm reading the restatement, and they came to dignitary harm. I think, what the hell is that? I'm in Washington. Everybody has a dignitary harm claim. The whole place. I mean, just turn on TV, they're going to whack the person's character and say he's awful. I just went through a governor's race in Virginia. This is interesting. Well, dignitary harm would be added to pain and suffering because they may not look as well, and that might affect their dignity, and you are going to hear about it as a separate damage element. Now, this farmer of everything says, we got enough damage rules already. But if they're pushing you for dignitary harm, as judges, you may want to ask them with some precision what is being protected that is not being protected already by some other damage rule. But it is right now in the draft restatement. Remember the number 2000. Torts restatements, judges, if they were, rabbis look at the Torah, ministers look at the New Testament, judges like the restatement. Look, it's black letter law, you don't have to read a lot, and I worked on them, I've been an advisor, and most of the people are pretty good who write them, but they're all academics. You put them all in a room, and the number of clients they have advised probably comes below zero. I mean, it's just, that's what it is. But they use big words. You see, they can do that. Like imprimatur. I sit there with a thesaurus when they're talking. I don't know what the hell they're talking about. I'm going to mention 3 trends in the law that you're going to see, and I've looked at all the tort law, and these are trends. It's not just cases. And one that you will face probably in the next month or so, if you have any major trial, is the admission of expert evidence. Now, I taught evidence at UVA, and that was real tough because UVA, when I taught there, was very intellectual. And I taught evidence to practice, because I've always practiced. How do you introduce this paper and evidence? The students were going, so what the hell do I do? So it was lucky. They had 101 students in the class. So I come in with a telegram. Anybody here remember what telegrams look like? They were these yellow things. There's Mary knows it. And I opened the telegram. I said, there's 101 students in this class. I have bad news for one of you. Oh, I thought, somebody croaked. I said, there's only 100 seats in the Senate. One of you is going to have to practice law. And it might be you, goddammit. Evidence. So, evidence. Experts. Wigmore, and he was back in the early 1900s. He said, expert evidence is a tough thing. We only put an expert on the stand, basically, if the jury doesn't know anything about the subject. And so how do they figure out which person is right? And that's a damn good question. The Supreme Court back in the 90s, 93 or so, talked about it. It's the only phrase I ever had that the court adopted in my whole life, but they adopted this. I said, judges should act as gatekeepers so that they do more than just look at where the person went to school and a general way that what he talks about. And I think there's a gatekeeping function. The plaintiff's lawyers say, Schwartz, you don't know what you're talking about. We can get it out through cross-examination. Yeah, but these are experts. They can testify as to hearsay. They can reach conclusions. They have all this superpower. And I'm not saying block experts, but gatekeeping role is important. It's in Federal Rule 703, which I think is being improved a little bit. And sometimes you need a hearing to really find out, is this expert, which Donald is, qualified to render his opinion? You don't have to agree with it. I totally disagree with it. But do they have the qualifications other than the suit and degrees from MIT? And that's a trend where it's going to be more and more pushed for experts, more and more pushed for experts, and the role of gatekeeping. The second theme, and there's only three, I'm going to mention, and this I trademarked. I like to trademark things. I trademarked something called judicial hellholes. One of these sessions, I didn't do it because judicial hellholes sounds terrible. So a judge from Pennsylvania comes up. He said, Schwartz, that wasn't a bad talk. I said, thank you. But you're the guy that writes the judicial hellholes. You call my court a judicial hellhole. Well, this guy didn't look too friendly. I said, oh, no, that's my colleague, Harry Silverman. I didn't want to take credit. Deep pocket jurisprudence. That occurs when a particular defendant who did the bad stuff doesn't have any money. He or she is drunk. They can't be reached by judicial process. But there's somebody else around who has a lot of money. Maybe it's a car company, maybe the car is defective, but maybe it isn't. So the drunk driver doesn't have any money, and tort law is stretched. One that is very frequent in the cases now deals with pharmaceutical companies. You probably know the Supreme's ruled that preemption, they talked about that this morning. Generic drug companies have preemption. You can't bring a duty to warn or design claim against a generic, but you can against a branded company. So there's a push to make generic competitors liable for what the innovator company did. It's crazy. But the Supreme Court of California, maybe they were out, maybe saw some movie stars, had a drink or two. They adopted it. So they took it in. Most courts have said no. And the Supreme Court of Iowa, is anybody here from Iowa? Oh, I like what they did. They called it deep pocket jurisprudence, and they said it was law without principle. And then they actually cited an article of mine. Holy crap. It was really written by Phil Goldberg. He's out there. But I pretended I wrote it. So deep pocket jurisprudence lurks. It appears all sorts of things. It can appear even with independent contractors, calling an independent contractor an employee so the person who hired him or her is liable. It's not good. It is law without principle. And it doesn't have signals. It's not like a pinball machine. And I just suggest to you, you're going to see more of it when there's a defendant that doesn't have money who really did the bad thing, and they blame somebody else. You don't want to blame an innocent party. If they've done something wrong, hit them. Let the jury hit them hard. But not just because the defendant who really did, he may not have even been named, the work doesn't have any money. And the last thing I'll mention is a term that I didn't come up with. Former Secretary of Labor Reich did. Anybody remember him? He was a little guy like I am. He came to see me. He used big words. I was in the government too. He was so smart. I went home with a dunce cap on my head. I felt so stupid. He's all these big words. You're Schwartz, you got to do this and this. It's okay, I write it down. Then I tore it up after he left. But he came up with a word, regulation through litigation. That's when you as judges are asked to do something basically because Congress won't do it, and frankly, they don't do anything. Mother's Day died, I think, about a year ago. It was a bad term or something. They just can't, they can't function. And then the administration doesn't function. So they have you be a regulator. Now, they don't come in and say, I want you to regulate it. But Secretary Reich came up with the term regulation through litigation. And at first, he liked it because he felt these other branches weren't doing these jobs. And then he went through a conversion. No, he did not become Jewish anymore. He went through a conversion on his thought. And he said that regulation through litigation is not democratic, small d. That the branches of government that are to regulate are the executive branches. And in a case that Phil Goldberg mentioned this morning in nuisance, Ruth Bader Ginsburg, certainly no conservative, said with nuisance issues and climate change in the case before her, that was properly in the hands of the executive branch, not in the judicial branch. You're tempted to do it because it's frustrating sometimes that Congress doesn't do enough to regulate certain controversial industries. But regulation through litigation is really not the job of a judge. You don't have the, I clerked, and I remember the judge would say to me, now, Victor, I can't get that document because the judge couldn't issue a subpoena the way legislators try to do. You can have the briefs, you can have amicus briefs, but certain things dealing with regulation are more in the province of other branches. Now, I could talk forever, but I won't. I like to keep the things short, like I'm short, and I welcome your questions. Thank you.
Thank you, Victor. I'm going to start off with a couple questions for you. One is, you talked a lot about the restatements in the ALI. How are judges supposed to evaluate the adequacy of the restatement process and the completeness and accuracy of restating the law versus moving the law forward? And in part, you did mention also this tendency that it is a source which is useful to turn to, it's easy to turn to, it is hopeful, I suppose, that it represents an accurate reflection so that it would ease the research burden on judges. But you've pointed out some of the ways in which even the current restatement might be recognizing a set of law that hasn't percolated up into any kind of consensus. So what tools would you give to judges to evaluate when and when not to trust a restatement?
If they were citing a restatement and some instinct said to you, especially new ones, I'm not sure about this, ask counsel to supply you with any articles about that restatement. A controversial one was the restatement of the law of liability insurance. Had never been done. And there are articles out there that show which portions of that restatement are not buttressed by cases. Currently, there's one called the Draft Restatement of Consumer Contracts. There already is a law review article out there showing that some of the sections, such as one for deception, which is a consumer protection part, is not based on any case law. The law review people or op-ed people now get to them. There's been a change at the ALI, and I like it. Their 100th anniversary is coming up. If you look online, I supported it. It's been good to me in many ways. I met all these people. But there's a trend now in some of the restatements that they are not restating anything other than it's the reporter's view of what the law should be. Well, that ain't a restatement. They have a doctrine, they have a thing for that at the ALI called principles projects, where if you want to look at the law of the future or something like that, it should be there. But they haven't always followed it. So I don't think as a judge where you're busy, you can get into the weeds on it, other than there's writings about it, and take a look, because all is not solid. Of all the things they change, because this one got to me, the first tort in my little case book, but in most of them, is the tort of battery. That's the simplest tort. It's called a harmful or offensive contact. So you don't just have to hit, but it's got to be offensive. Offensive to a touching that's offensive to a reasonable person. Somebody puts ketchup on you or something like that. Well, they're trying to turn part of it into a subjective tort. Well, I don't want to be touched by a pencil, and he's in the workplace. What the hell are you going to do? You give him a pencil, and then he gets a battery claim against you? So there's no case law support for that. They have one dissenting opinion. But it was addressed by the Wall Street Journal. It's been addressed in law review articles. So that's the best I can do. Just be careful. Most of it's good.
With the appropriate level of caution, is there a role for the restatements, if understood as serving something other than restating the law, to help to clarify an emerging area of law? I have products liability in mind here. So I had the good fortune of learning products liability from Jim Henderson while the products liability restatement was being drafted. And so we learned from the drafts, and at least I thought it was a very good way to learn it, but I'm not so sure that I was learning what I was learning.
Well, the restatement of torts, third, products liability, is a darn good product. There's things in there that help plaintiffs, defendants, and Rabbi Twersky and the late Jim Henderson were really terrific co-authors. And every part of that restatement, if you like it or not, is propped by case law. So it is a solid work. There is debate in the ALI now as to whether restatements have to rely on cases. The benefit when they do is it's simple. A battery is a harmful or offensive contact. That's what they say. You start reading product liability cases, it takes forever. Some of the appellate judges who I love, they don't get writer's cramp on a particular day. So they're writing a decision 60 pages long. It's easier to look at the restatement, see what they say. For example, is there a duty after you make a product to warn about a risk you discover later? Well, you can look at the restatement, and it's plain English, and it helps you that way.
So I want to go back to your advice on regulation by litigation for a moment and talk about the role of judges in evaluating the appropriateness of sort of stepping back and saying, oh, I'll let the legislature do that. Common law courts in particular are said to be evolving. Common law doctrine evolves, and that there's some leeway for judges to adopt new rules according to evolving standards and such. What advice would you give to judges in evaluating that mix of, okay, when do I defer to the legislature, and when is this within just the natural evolution of the common law?
Well, one of the benefits it made me think, I love these things because I always learn more than I provide, and I learn from you judges. And on that question, it's just my sense that you as judges, the judges I've met here, you can get it. When the issue is one involving public policy that's beyond something that's a case. For example, holding a oil manufacturer liable for climate change. Well, sitting in a courtroom figuring out the causes of climate change, it's not like whether the light was green or red. It's a public policy thing. And in your judgment, it's up to you. If it's a real public policy thing that goes beyond a case, then, and it would affect behavior of people who make firearms, people who make oil, then that's for other branches. And it's cited, Phil has it in his materials, Justice Ginsburg's statement about what fits and what isn't is very good. And I'm reflecting, or not stating as well as she did, her words about areas of public policy that are really beyond the purview of the court because you don't have the information. It's bigger, and that's the best I can do.
There is that risk, though, that nothing gets done, right? So there's dysfunction, there's gridlock, and if not the courts, who? Because those institutions can't produce product. Do we just have to accept that and live with no rule because the courts have to stay constrained?
That is what former Secretary Rice thought in the beginning. If the courts don't do it, nobody will do it. But we still have voting machines. And some of them work. Like in Virginia, I went and voted, and it worked. It actually came in the mail. And I first got none, and then I got 2, but I shouldn't tell that story. I
Well, now we know
will
why it
never use
works.
the word screwed up with this audience. So they can, it's up to the branches of government that are supposed to do it to do it. Firearms actually are pretty regulated. If people want them regulated more, vote the people in. Congress passed a law that froze the tort law against gun manufacturers back in 2005. If people don't like it, you elect different people. It goes to the heart of our democracy. It's slow. It's who said it was the worst of all forms? But there's nothing better. Maybe Churchill or somebody like that. So it is up to who we elect. And there has been, at least in my years in Washington, it's what's in the paper. There's gridlock there. They're all gridlocked. I'm hopeful. I think it will get better. I think it's reached a point where it's going to get better. It's just my feeling. I liked it. I don't know if any of you remember John Dingell. He was one of the great men I've ever met. He was a congressman, and he had a Republican opponent, minority, Mr. Broyhill from North Carolina. There's more Dingell-Broyhill bills than you could ever remember. I do think we're going to get more back to that, and that some of the gridlock will be lifted. So the answer is democracy. But it's not the judge's job. It's not his or her job to supplant Congress that won't get along.
Can you reflect a little bit about your work in that field, your work in legislative, state legislative and federal legislative work, and how you've seen that as a useful tool to lead to better rules and or to, in some ways and at some points, constrain the courts when they've gone too far?
Well, most of the stuff that goes on that in my field is at the state level. And just as a little man, I love dealing with state legislators because they're real. They have a job, they earn a living, they have family. I never met a stuck-up one in my life, and I've been in at least 42 states. Congress should rarely come into tort law. It's got to be, so some things like they want to deal with damages, that's at the state level. A legislature may feel there needs to be some type of limit on non-economic damages. Maybe they can figure out what to do. Sometimes, by the way, forgive the aside, but it's very real, state judges will nullify what the legislature has done. And they always use state constitutions. This was a brilliant idea by a plaintiff's lawyer who I knew. I got a little piece of their lecture. He said, never use the federal constitution. It doesn't work. Use state constitutions. So when they nail a tort reform that's mentioned by a state, they use the state constitution because the state constitutions are like hundreds of pages. A ham sandwich, unconstitutional as some kind of interference with property or something. Some crap, something like that. So you can hold anything unconstitutional. And then you can't go to the Supreme Court. There's no federal issue. So very often they get knocked down, but not that often. When there's something big, back in the early 90s, my love of my life, Debbie, her dad used to, he just said, I could do him cold. Oh, I know what you do for a living, Victor. You go up to the hill with bags of money. You're basically a bum. Imagine you're like potential father-in-law. I said, well, only one bag. I didn't want to be, I was in the minor premise technique. So he said he couldn't buy a new plane. This is a rich man's lament because of liability insurance. And I said, he said, get something through Congress, do something good, because they're suing for 50 and 60-year-old planes, and that's making these private aircraft unavailable. So I'm just giving you how it happens, not what happens, how it happens. So I go back to Washington. I knew they had a trade association named by two tall Ed Stimson. Everybody's taller than I am, but he was like 3 times the size. Hello? Yes. So I said, here's the deal. Everything about planes is regulated at the federal level, including the driver's license. It's interstate commerce. We're losing this industry. And 2 years later, President William J. Clinton, who was kind of thought of as being pro-plaintiff, signed the General Aviation Revitalization Act. And it says after 18 years, assuming good performance, there was no liability. And Nancy Kassebaum helped me, Dan Glickman, a Democrat, helped me, but a lot of people helped me. And I got Mr. Underhill an enrolled bill, and I remember him saying, well, with all the money you made, you could at least got me a plane. I mean, this is life, friends. But it passed, and it helped bring back an industry, and it was a paradigm. And right, we're near the end, but I love this. The question I would get again and again, and if you've heard this, how did you get President Clinton to sign a tort reform bill? I don't know how to get the president to sign anything. But he had Bruce Lindsay was his aide. Nothing went by with Bruce Lindsay. So I needed an answer. So I said, look, I want to say this right now. Bill, Bruce Lindsay took my glasses. I thought it said tort reform, so I signed it. Thank you very much.
All right. Do you mind taking a couple questions from the audience? Sure. So if people would like to come to the mics, and if anyone has any questions for Victor, as people move toward the mic, I do want to ask you one last question, Victor, and that is, what role does economics play for tort law, and how does tort law help our understanding of economics?
I don't know the answer to that. I know it's very important. It has more and more being taught in law schools, but I don't have the expertise to properly answer that question. I know and I don't know. I should know more. I think it's vital that people learn about it. I learn at these sessions, but I don't have an easy answer to that question.
All right.
Okay.
I think it just fell, let's see, it just fell down. It's under your foot.
Oh, good.
All right.
Is it working now? Good. Thank you.
Great. Well, I think that concludes our talk. We've appreciated having all of you here for the past, present, and future of civil justice. Actually, let me ask one last question before we close, though. What is civil justice in your mind?
Well, I see it as forms of recovering for harms and the whole matrix of law that deals with compensating somebody for an alleged harm, continually sometimes defining what a harm is. And it's the entire field. And it's been discussed a lot today. It has procedural aspects like discovery, admission of expert evidence. So there's a procedural component, and there's a substantive component, which I discussed in the first part of my talk. And to me, that's what it is. And it's like justice itself. It's subjective. What is justice to one person may be injustice to another. So,
well, that will be our goal and our task for the next day, to get even more answers to what is civil justice and to see how we achieve more of the justice and less of the not. So please join me in thanking Victor Schwartz.
thank you.